Welcome to Family Law Mediation at the Minnesota Court of Appeals. My name is Edward Toussaint. I serve as the Chief Judge of the Minnesota Court of Appeals. We have decided to mediate family law claims appealed to this court. Through mediation, we hope to reduce the adversarial nature of family law claims. We have asked trained and experienced mediators to preside over the mediations, hoping to resolve your claims. You can be assured that these mediations are confidential. They are separate from our other court functions. Discussions during mediation cannot be used in later court proceedings.
Decisions that husbands and wives are able to make for themselves with the help of attorneys or others, including mediators, those decisions are going to sit much more comfortably, if you will, with the parties. You will discover that you're going to have far more personal involvement and input, if you will, into the mediation process than you would have were you to continue with the appeal process in court. As I'm sure you probably know, in our court we hear only from the attorneys. I'd like to take just a minute and talk with you about the most important issue, determining where the best interests of children lie. And as I indicated earlier, husbands and wives are in the best possible position, not only to make their own decisions about all of the other issues, property and support and maintenance, but most importantly, are you in the best position to make decisions regarding the welfare of your children, in the best interests of your children.
When mediation occurs, that is the question that's foremost in the minds of everyone. Can I settle this case? Should I settle this case? What are the advantages in going ahead? The party who initiates the appeal, called an appellant, has an uphill battle, to put it in the plainest language. The burden rests on that party to show that there's some cause for review. It's a burden. It is a load on one's back that must be carried up a hill. And if the load is not borne, if the goal is not met, the appeal will not succeed. And most of the time, the appeal will not succeed. This is a reality because of that burden. And that burden involves, I might add, just one consideration for both parties. And that is to very carefully look at the details of what is contained in the trial judge's order. You'll see that it's broken into two parts, findings of fact and conclusions of law. Those are the labels given to it. If you're appealing and you have a burden to show error, you want to look through that order with a fine-tooth comb and asking yourself this question: where precisely is the mistake? If you're saying there was a mistake, point it out, identify it very precisely. And likewise, the respondent looks at that same order and makes that same judgment. Is there really a mistake here?
The trial court also exercises discretion in determining which witness is perhaps more credible, more convincing. The trial court exercises its discretion in connection with many, many, many of the decisions that it's called upon to make. If an exercise of discretion is clear, our court grants great, great deference to the trial court. you are at the beginning stage of your appeal. You have not yet incurred perhaps many of those dollar costs that would be ahead of you. Preparing transcripts, simply filing the documents, preparing the briefs, and so forth. So those are dollar and cent costs. There also are costs in terms of time. From the time you file your notice of appeal to our court until the time that you have our decision in your hands, so to speak, it'll probably be a year. Mediation may take you a matter of days, depending on how that matter goes, but certainly not anywhere near the involvement of time that an appeal would be. At the end of a year in our court, you may receive an opinion that affirms what the trial court has done, and that may be the end of the matter. It also may not be the end of the matter. If one of the parties wishes to try to take the matter to Supreme Court, the likelihood of Supreme Court accepting the matter is slight. But even before we would know of the Supreme Court's refusal to consider the matter, probably another several months have elapsed. What if our court, in its decision, sends the matter back to the trial court? Now you're back in trial court, again, the elapse of many, many months, probably. Perhaps the most important cost factor is that of the emotional toll that is taken upon both parties as you go through lengthy litigation, acrimonious litigation. To the extent that the litigation prolongs your ability to get on with your life, so to speak, to say, okay, that chapter is closed, those decisions are made. It is so much more beneficial to have the matter decided by yourselves at an early stage of the appeal process.
Mediation isn't for everyone, and mediation may not be appropriate if you're dealing in a family situation where there has been a pattern of domestic abuse. This process can be very difficult for some people to participate in those circumstances, and you'll be given good advice that this may not be for you in that case.
I would urge you to give every good effort that you can muster to enter into the mediation process, to work through that process with the goal to, again, to reaching your own decisions, enabling one another to go on with your lives, and if there are children, to know assuredly that you have done the very best that you can to ensure that their interests are fostered, nurtured, promoted, and recognized.